to let everyone know that doesn't already, my name's Zoe Malem and I'm head of events here at Inspired HR. We've put together for you, as you're all aware. I'm sorry if you guys can also hear that ding. I don't know how to turn it off. We've got some employment law changes. As some of we're aware that have read our blog post, a lot of this stuff isn't quite kind of set in stone yet. So there's going to be a lot of conversation between Nikki and Kat. Now, I'm not going to try and introduce either of these two fabulous ladies. They're going to introduce themselves in a moment. But there were just a couple of housekeeping bits from me. We can try and stay on mute for the entire section where the team are presenting. That would be great. They will open the floor and they will actively say, guys, if you have questions or does anyone want to chip in here? Use the chat function throughout if you're not confident to raise your hand and to ask any questions at any point throughout or at the end when we have 15 minutes of Q&A. Put them in the chat and I'm going to read them out for you. And anything you need in the meantime, in terms of if you want to write your notes in the chat and like say, ask this at the end kind of thing, but we'll see. So we're going to guide you through the whole thing. Hopefully that all makes sense. You're going to learn lots. So please make sure you've got a pen and paper handy so you can write loads of notes. We are going to stick to time. So we're due to finish at 3 o'clock on the dot. Just before that, we'll have 15 minutes of questions. Anything we don't get to answer, you are more than welcome to come and reach out to a member of either Richard Reed or Inspired HR team directly. So I think that's everything from me. We are going to talk about our next events at the end of the day, because it'd be rude not to, wouldn't it? And we'll also update you on anything else that Inspired HR has going on. So just for those who arrived a little bit late, if you can stick for us, it's all being recorded and you can change the view to speaker view in the top right-hand corner. And I think that's everything from me. Learn lots, have a great time, and I'll pass you over to Nikki Masterman.
Hi everyone. So for those who haven't met me before, I am Nikki Masterman. So I'm going to start off with a little bit on the slides and just start moving them over. Oh, just bear with me, my computer's thinking about it. So Zoe Malem has already introduced herself to you guys. For any of those that want to connect with Zoe, who is my head of events, the QR code is there if you've got your phones handy. Do connect with her because she's very well connected on LinkedIn. We are also, my computer's on go slow, bear with me, it's thinking about it, there we go. So I will let Kat introduce herself. So Kat, I'll hand over to you if you'd like to tell everyone about yourself.
Hi, good afternoon, everyone. I'm Kat Moody. I'm a dispute resolution and an employment lawyer at Richard Reed, based in Sunderland. And me and Nikki often work or collaborate together on employment and HR matters. So we're very familiar with how each other work. And so when this came up, this topic, it was kind of quite natural that we wanted to deliver it together and hope that you find it interesting. But because I know we've got a lot to cover, I'm not going to talk for a long time about myself, but I'll pass back to Nikki and she can introduce the first topic.
Fabulous, thank you, Kat. Okay. God, my slow computer, apologies, my computer's on go slow. Oh, don't you love it when your computer stops working? Okay, so I'm hoping it's now not done. Suddenly jump a load of slides ahead. Okay, so for those who haven't met me, I am Nikki Masterman. I am the founder and managing director of Inspired HR. I have done HR for what is my 33rd year now. I have not gone the academic route. I'm qualified by experience, and I'm what I refer to as I have learned HR through curiosity. So everything I've achieved in my career and in business is through curiosity to learn. Extremely passionate or enthusiastic, as people know about HR, and generally love what I do. From a personal point of view, I've been in business 7 years. I set up Inspired HR as a sole consultant 7 years ago, and I grew to the business that it is today. We are nationwide. We are a territory license model, which means we have multiple people nationwide with their own areas under our brand. And we cover everything from mediation, coaching, recruitment, HR. For anyone who knows me, they know I am extremely no nonsense. I don't suffer fools gladly, and I can be quite straight and blunt in the nicest possible way. So we're expecting some conversations today that'll be quite interesting. So without talking any more about myself, because I'm sure if anyone wants to look me up, my QR code is there and I'm on LinkedIn. Feel free to connect with any of us. And all of the slides will be coming out to everybody as well as the recording. So let's start off with what has already changed this year. So we did a webinar earlier in the year where we talked about Carers Leave Act, the holiday pay for irregular workers, flexible working, protection from redundancy and paternity. So there was quite a lot of changes earlier in the year. And then in July, we then had obviously the TUPE changes and then obviously fire and rehire, which we will be touching on briefly a little bit today as well. So just something about fire and rehire, obviously that came in July, and I know there was quite a bit of unrest on that, but actually I've been in HR 33 years and I've never had to fire and rehire, because even though I am very no nonsense, I'm also a big believer in everything starts with a conversation. So if you practice good practice within your business or within your employer in relation to your people, and you talk to them and you have a proper conversation, you shouldn't end up in a situation of fire and rehire. We get that it happens sometimes. We saw it happen in P&O a couple of years ago. We saw the damage that's done, which is why some of this legislation has changed. But to be honest, I've never had to need to do it, but I have seen it happening in P&O and some of the bigger food retailers I used to work for. So for anyone that didn't see our webinar earlier in the year, it is on our YouTube channel. When we send everything out after this, we will give you the link if you need to catch up on some of the legislation that's already come into place already. So what is still going ahead this year? Well, we were expecting around about September, October time, and we'd done lots of preparation for this, but we were actually expecting the right to request a predictable work pattern to come into play. Now, originally they said autumn. We thought it was going to be September. We were all geared up for it. We had new policies lined up, ready to roll out. And then the government announced a couple of weeks ago they've now put it on hold, and it's now going to form part of all of the Labour manifesto when it comes to the additional changes for flexible working. A little bit frustrating that they left it so last minute with the amount of preparation, obviously, that many of us have been doing, especially when you have a large retained client base and you have everything ready to go, and then they decide to stick it on hold, and we actually don't know if that's what it's going to look like. So, though obviously the predictable terms has now gone on hold. What is coming into play in October, though, on the 1st of October, is the allocation of tips. Now, the allocation of tips legislation that's coming into play is actually causing a lot of confusion at the moment, because there's a lot of script and blogs out there that talks about it heavily impacting hospitality. And what that's actually leading to is people trying to understand whether it actually impacts them. But in reality, the allocation of tips affects any business that has regular tips. So you're talking hair salons, nail salons, beauty salons, anywhere that operates tips. It is not just going to be hospitality. And that has really caused some confusion where we've had regular calls going, does it affect us? Yes, it does, unfortunately. So for our clients, you don't need to worry. For our retained clients, because we've got you, we'll be in contact to talk about what that looks like with you and make sure your policy is actually bespoke to you, because it can't be a standard policy. It's bespoke to a number of factors as to how those tips are allocated. But to give you an idea overall, because there's no point in me going into a lot of detail on this, because we're going to be covering a lot today, and I'm always open to another conversation separate from this. But basically, employers are required to pass on all tips to employees, whether that goes through the till or it's cash. It's not just cash either, tips. It could be on in full to employees. The legislation is basically saying that the passing of these tips, as I will refer to them as, must be fair and transparent. Again, when it comes to employment legislation, they'll quite often use words that people will reasonable when that's used within employment law as well. So the fair and transparent process. There's some strict guidelines around allocation of tips now. So records must be kept for 3 years. So everything you pass on to an employee in relation to tips, you must keep a very detailed record. You must be fair and transparent and show how they're being allocated. The employee has the right to request them, as does HMRC, and they will be overseeing this very strictly within sectors. If an employee requests to receive a paperwork, they can only request it once within a 3-month period, and you have 4 weeks, very similar to GDPR, where you've got to respond within a short period. You must have, if you are a business that has regular tipping, you must have a policy in place. Now, there's a number of factors as to that you have to consult with your employees on. So what does that mean? So that means that you must decide whether, if you're in hospitality, it's going to be shared out across everyone, including kitchen staff, so back of house, front of house, or whether it's going to be the person that's received it. You may have customers that are asking and stating it goes to their server. So you've got to determine what factors will be taken into consideration, and those tips must be paid through payroll, and national insurance and tax, unless they're trunk, will apply. So you have to make sure it goes through the pay slip. So very simple. Tip and they didn't get it, they can bring a claim against you for it. So it's really important that you.
Sorry to jump in there, Nikki. You froze a little bit. Can you just rewind the last kind of 30 seconds a minute, please? I got up to you were about to tell a story about someone, and then I think we missed the story, and then you told us the outcome. So if you could just repeat the story.
Sorry. So we're getting a number call, a number. I'm completely lost as to where I was up to. So I'll go back a little bit. So you must have a policy in place if you are a premises or sector that operates with regular tips. Any tips that you receive must be issued to the employees within 1 month of receipt. Now, me and Kat were talking about this earlier, and that's actually going to be quite hard if people are running monthly payrolls, because you often have a delay in the way sick, holidays, tips, things are going to be put through payroll. So we know that's actually going to be quite hard to enforce, but it must go through pay slips, and it must be on the pay slips, and deductions do apply. Now, that obviously is going to cost businesses where national insurance is going to be taken into consideration into business contributions. So you are going to need to bear that in mind. But some of the factors that will need to be agreed and obviously consulted to the employees to agree what these policies and how tips will be allocated will be things like back of house, front of house, do everyone get a share? Does it only go to that individual? Who was on shift, what day? And very, very detailed tips and allocations must be kept, because people basically it's coming into play. Now, from a client point of view, we obviously will be in contact with all of our clients to agree what that finalised policy looks like for you. That allocated. It can be complicated, and we do think there will be some avoidance on it, but businesses do risk a claim if they don't manage it properly. So there's a lot more to probably talk about on tips, but I'm not going to, because I think it's probably not as complex as the piece that Kat's now going to talk about, which is around the prevention of sexual harassment. So I'm going to hand over to Kat on that one.
Great, thank you, Nikki. Yeah, so the second piece of legislation that is actually coming into place this year, and we do have more information about it, is the sexual harassment in the workplace legislation, which is due to come in place on the 26th of October this year. A lot of literature is already out there with guides and tips and helps to, guides and help for employers to make sure that things are in place now, so leading up to this implementation of the Act, so that you're fully briefed of what you need to do and that you kind of ahead of the curve, because what you don't want is to breach the legislation, because the sanctions can be quite disastrous for employers. So the new legislation is the Worker Protection Amendment of Equality Act 2023. What it does is it places a positive duty on employers to prevent sexual harassment by employees and third parties, or at least to take reasonable steps to prevent sexual harassment in the workplace. But I think the first thing really is to make sure that everybody is familiar with what sexual harassment is. So sexual harassment is unwanted behaviour of a sexual nature. It must either violate somebody's dignity, either with intention or not, or create an intimidating, hostile, or degrading environment. There doesn't have to be an intention. So this is the difficulty. A lot of people who are accused of and who are guilty of sexual harassment may not have realised that the comment or the action that they took could have amounted to that behaviour. So it is really important that we have education about what sexual harassment is. The Act only puts this duty on employers in respect of sexual harassment. So we're not talking about any other type of harassment in this instance. We're only talking about sexual harassment. The other thing really that you really need to be aware of is the Act says you have to take reasonable steps to prevent sexual harassment, but the Act unhelpfully doesn't define what reasonable is. So what I might think is reasonable may be different to what Nikki might think is reasonable, or another employer. And so it's about having a really well-minded view as to what you think the majority, what you think most people will think is reasonable, and do that, because there is no definition. So there is some helpful guidance that's been introduced, which we can pass on to everybody if you would like to have more reading. But effectively what that does is it gives employers reasonable examples of reasonable steps to take. And what they suggest is that you as an employer adopt a zero tolerance policy on sexual harassment, that you display notices in private and public sections of your building, wherever you work, that when you engage with third parties, before you even agree to work with them, you put them on notice of the zero tolerance policy. You even get them to sign to say that they've acknowledged that. You need to basically do everything that you can in order to demonstrate later down the line at a tribunal, if need be, that you did take reasonable steps to make sure everybody who engages with your business is aware that you don't tolerate sexual harassment in the workplace. The other examples were making sure that you have robust training. So, and it's not just a tick box exercise, it is training that is specific to the industry that you work in. It's specific to the situations that your employees might face. So if you've got front of house staff, what kind of risks they might face could be very different to back house staff. So you need to be thinking and identifying what risks to sexual harassment exist in your workplace. You also need to train managers, have robust reporting procedures in place so that everybody knows who they report to, and also so managers know what they do when somebody raises a sexual harassment allegation. So there is a lot of work that needs to be done, and things that now need to be put in place in order that you are ready for the 26th of October. The last thing to mention on it really, so you're aware as to what will happen if you don't comply, is that you can be fined. Action can be taken against you as a business from the body that oversees the Equality Act. And also, if you're taken to court by an employee, any compensation that they're given can be increased by an additional 25% if it's deemed that you didn't take reasonable steps to prevent sexual harassment. And lastly, the Equality and Human Rights Commission have just published an article calling for employees to actively report sexual harassment in the workplace. So they're now cracking down on any kind of this behaviour in the workplace, and they're actively seeking employers to take action against. So it's not a scaremonger, but it is to make sure that everybody's aware that it is a really important piece of legislation, absolutely essential in the workplace to protect people at work. But it isn't just from your own staff, it is from other people that you work with. So third parties are just as important. So you need to make sure that you're preventing sexual harassment from third parties as well. And that's everything on that. And that's actually the only two bits of legislation that are still going ahead this year that we're going to focus on. The next part of the webinar, really, we're going to look at the other things that Labour are now suggesting that will change going forward, looking at the manifesto that they've put forward, making work pay. So I'll hand you back to Nikki, and I'm sure she'll introduce that.
Thanks, Kat. So as Kat said, they're the only two pieces of legislation going ahead this year now, but actually the level of work that is going to be needed around them is quite substantial, especially if you are a sector that is impacted by both of them. Now, with the sexual harassment side, again, for our clients, we are going to be introducing training. We are going to be introducing templates that you can issue to third parties and your employees to sign from day one or when people come on your premises. So a lot of these expectations that are around a reasonable prevention, we will be implementing full-on packages for our clients around that. So, so don't worry at this moment in time. We will be working with you on that. But we are now going to be nipping into what we call Labour's plan to make work pay. So, see if I can get the slides to move. There we go. So, I don't know if you can see me on screen because obviously it depends on all of your screens might be a little bit different. You might be able to see me and Kat, you might not. This is the document that I downloaded from the Labour government. So we've based our presentation on this and the way they've split it up into the key areas. Now, when we walk through this, we are not going to go through everything in detail. We will send a copy and the link of this out to everybody so that you do take time to read it. It doesn't go into masses of detail. It just uses typical overwording around the manifesto. But myself and Kat are going to cover off some key areas that we think are going to be really highly impacted. Now, just something to note about this, obviously the Labour, we're obviously going to be talking parties here, and I'm going to read you some quotes from this in a moment that are very heavily where Labour are criticising Conservative. Now, I do happen to know we have somebody on this today that actually was a candidate for the Conservative MP in the recent election. If she wishes to join us in any of the conversations at some point, she's more than welcome. Please note, I am no way in any way political. We're just commenting on what the two parties are saying, and there is certainly no comments that we are sharing today that they're made on our opinions rather than representing our businesses. So please be aware of that on anything that we say. So what have Labour stated in relation to the Labour plan Make Work Pay? So some key fundamentals just going from this document is under the Conservatives, we have seen a lost decade when it comes to the world of work. That's quite a big statement for Labour to make. They've also said, another key statement, we will be bringing in a new partnership with businesses and trade unions to turn the pages on 14 years of failure. Now, we can see quite a big influence within this whole manifesto in relation to unions, and Labour have always been known to be the party that have worked very closely to unions. Now, from a personal point of view, I've been in HR for 33 years. And what I've found over that time is that I've seen the visibility of unions actually slowly diminish over the last about 15, 20 years. I have really seen that reduce within many of the sectors that I've worked in. So I think there's going to be a lot more visible presence within HR meetings, within workplaces now, and of the union being visible in the workplace, because obviously the union are now being encouraged quite heavily as part of this manifesto. So a few key things that I've kind of picked out from the document before we move on to the slides is they've talked about we'll boost wages, make work more secure and support working people to thrive. We'll deliver the biggest upgrade to rights at work for a generation. And let's not underestimate this, guys. Let's not panic, but do not underestimate the amount of change that is going to occur. Is it all going to happen in October? No, they're just going to be announcing potentially what is coming and what the timeframes are, because there will be a lot of consultation, and some of this could take years because it has to go through the different parliaments, it has to be signed off, it has to go through consultation. So certainly don't panic that it's suddenly going to hit everybody at the beginning of next year. They said they're going to hit the ground running and introduce legislation with 100 days of entering government. And they're going to fully consult with businesses, workers and the civil society on how to put the plans into practice before legislation is passed on it. There will be stronger trade unions, which we're already seeing in the manifesto. And like I say, I do think we're going to see unions a lot more visible within the workplace again. And collective bargaining will be key to tackling problems of insecurity, inequality and discrimination, poor enforcement and low pay. The last Labour government lifted basic minimum rights in the workplace by introducing the national minimum wage, the 48-hour working week, the 28 days paid holiday, parental leave and greater protections from unfair dismissals. And they're saying that the Tories oppose them all. So they're saying that they're responsible for a lot of the changes historically anyway. So let's move on to one of the key areas. So me and Kat, so what you have to remember about as we go through this, there is no key legislation yet. There's just summaries of what they think or what they're trying to implement. So what me and Kat are actually going to do is we're going to be talking about some key things. So you'll notice on this slide, anything that's highlighted in red. So under end and one-sided flexibility, you've got your 0-hour contracts, you've got your fire and rehire, you've got your basic day one rights, we've got your single status of worker, your redundancy rights and TUPE, your whistleblowers and your self-employment. So there's quite some key fundamentals under this section within there. But me and Kat decided to focus on 3 key areas that we really think is going to, where we most primarily work with smaller businesses, where that's really going to impact some of these smaller businesses. So 0-hour contracts, Kat, where do we start on that one?
Well, I suppose the first thing to consider is what is a 0-hour contract, really, just to make sure that everyone is aware that they are quite common. They are very popular in certain industries and sectors. Effectively, an employer doesn't have to agree to give a worker a minimum amount of hours, and the worker doesn't have to agree to accept or work a particular amount of hours. So it is very flexible, but it also means that the worker isn't afforded the same rights as an employee is. So a worker doesn't have the protection from unfair dismissal because they're a worker, not an employee. They don't have access to a notice period because they don't know when they're ever going to work anyway. That they're right, that their contracts are a lot less, the heads of terms are a lot less than employment contracts for an employee. And so you can understand why government are now saying that there needs to be some level playing field with 0-hour contracts, because they are a contract, they are something that can be exploited by employers who, don't want to or can't offer guaranteed terms or hours to an employee or a worker. And so they opt for these, but they don't suit everybody and they don't suit every situation. So Labour had suggested, which I think hasn't been met greatly by employers, that 0 hours are actually abolished completely. And there's been quite a lot of talk about some employers. There was a big study done, a lot of employers said that 0 hours should stay, but that they perhaps should be reformed. And also that I think the general consensus was that if they stay, they should only be used in very specific circumstances, in very specific industries where demand does fluctuate. And so an employer can't guarantee to give a person a particular number of hours. So seasonal workers, you can see it being sensible for certain jobs, but not others. And I think that's really where the focus has been, Nikki.
Yeah, I mean, we've seen a number of changes around the 0-hour contracts. When the Brazer holiday calculations came into play around the 5.6 with irregular hour workers, we actually discouraged our clients from using the contract. just note, oh, have I frozen? So we've discouraged historically the use of the 0 hour when all of the holiday calculations changed due to the, the implications when people weren't working, and encouraged casual contracts as an alternative so that they weren't accruing the holidays during the period of non-working. However, we saw that change in April this year, where they've now gone back to using the 12.07%, meaning that people can sit on the books without earning holidays. But obviously that depends on when the holiday years start, and we're still seeing huge confusion within employers as to whether 5.6 applies, 12.07. We do see the misuse of 0 hours in sham contracts, and we do say to employers and clients that contact us, we'll always dig into why are you wanting a 0 hour contract. We don't send them out automatically as part of our packages. We seek to understand why they believe that they need them or what they're going to be used for, to make sure that they are using them for the right reasons and it's not a misuse. But I think they do have their benefits, especially now they've introduced the rolling holidays and the 12.07% back. But I think there is always going to be a risk of them still being abused. And actually the wording that the government abused is getting rid of exploited contracts. And again, I think it comes around what is the definition, that this first of all said to the unions they would get rid of them. Now they're saying they'll get rid of exploited. So I know there's a little bit of mistrust from what I'm seeing and reading as well between unions and Labour in relation to they're now using the word exploited. So there is still confusion. Do they have a place in the SME world? I think they absolutely do. I think the sectors that need them, the seasonal workers, your Christmas workers, your summer holidays, there is your alternatives of your casual contracts, but it brings out on them.
Yeah, and I think also, Nikki, that these are just proposals that are, perhaps the end result will not reflect what's currently in this manifesto, but it is definitely food for thought, just to keep an eye on the, whatever's published next in respect to 0 hours, just to, especially for small businesses, to make sure that you're not solely relying on being able to use them, because they may not exist in the future, or at least not in the same respect as they do now. But I think there's not really a great deal that's been published about what else they're suggesting for those. I think it's either they're going to stay or they're going to be reformed, and we're going to be able to use them in certain aspects only. And it's a wait and see, unfortunately.
Yeah, it is. And I think, we proved during that period where the holidays went to 5.6 that actually where we discouraged the use and actually stopped issuing them, unless it was by absolute exception, where we believed that it did fit what we deemed a 0 hour need. I think there is the potential they could be removed and alternatives put in place, people on low amounts of hours, and it's reviewed every quarter and 12 weeks and things like that. So there is alternatives, but I think it's a watch this space and see what they come back with, because they've changed the wording once already on it.
Yeah, I think moving on to the fire and rehire, that's quite an interesting topic that they've covered as well, although they haven't really given a lot of literature again on that. But for anybody who's not familiar with the phrase fire and rehire, it's really when an employer uses the practice of making employees redundant and then offering them a new contract on less favourable terms. So then, it's not a practice that's encouraged. It's not a practice that I came across in in SMEs at all. But you did hear, a few years ago, P&O, they made 800 staff redundant instantly, and then they offered less favourable contracts to agents. Or, an employee could be forced almost to be in a position where you're either going to lose your job or you must vary your contract and take less favourable terms. So in July, there was the code. The code was introduced in July, which is supposed to be there to give employers guidance as to about fire and rehire and the practices that you should follow.
Yeah.
What Labour are saying is that they now want to expand further on that, and actually the code doesn't go further enough. They want to look at legislation. They want to bring in something more to make sure that fire and rehire is not something that people use. And in fact, I think when we were looking at the statistics earlier in the week, Nikki, with all of the labour kind of literature, most employers said that they thought fire and rehire should be outlawed and it shouldn't be something that they should be able to do. So I do think everybody's kind of on the same page about it.
Yeah, and you know, like we say, we saw through my career, I spent 24 years in corporates. You know, when I was in those big retailers, we did consult, and there was changes that was made when it come to bank holidays and working weekends, and we did consult and go down that route with them. There was certainly never anything threatening. But I do know there was one of my previous employers a number of years ago that did introduce some enforced changes when it comes to people working evenings, weekends, bank holidays. And I actually had a number of employees from my career historically that contacted me to make me aware of it. You know, but it was just unfortunate that they didn't make me aware of it until way after the time frame. And it was quite disappointing because it comes back to that it all starts with a conversation and treat your people well. You know, our commitment as a business is to inspire great HR, and forcing someone and going down that threatening route just goes against the values and culture that businesses should be building around, you know, attracting and retaining great employees. For an employer brand, you want to have that reputation. And I've certainly never experienced it in the last 7 years of working with SMEs. And even within my corporate career of 24 years, it was always a conversation and a consultation, and it was an agreement that was reached rather than anything ever enforced. So it does happen, we know that, and you know, it was on the back of the P&O that they started to have a look at this to make sure that nobody was ever in that position again. But it's about good practice. Treat your people with respect and have a conversation. You know, some of these are lives, and people don't want to worry about things like that.
And I think also it is about your employee having the faith that the contractual terms that they've negotiated with you at the outset of their employment are enforceable, are going to give them protection, that they're not just going to be dismissed and then forced into a situation where they're either unemployed or they take terms that don't suit their needs. And I think the idea of the reform of this area of law is really, you know, it's a practice that isn't used by, it's mainly larger companies that seem to get away with it. So the smaller companies, you know, you might not even notice a change. But again, it's just something that it's really important to be aware of, because it may affect people in your own business or people that you know, friends, family. And it's just good to be mindful of the changes that are likely to come in. And that is building on what's already been introduced in July this year. But I think that the next thing was, the last thing on this slide was the basic day one rights, which is, you know, a minefield in itself. You know, employees currently usually have to have at least 2 years service before they get rights for unfair dismissal and a whole other bunch of rights, unless, of course, there's a particular reason. You know, if it's an automatic reason for unfair dismissal, they've got a disability, a protected characteristic, whatever it is, they don't need to be there for 2 years in order to take action. But in general, an employee does need 2 years service. And so what the government are suggesting now is that employees should have more day one rights. So from day one, if what the government suggests comes into force, they're saying from day one, your employees could bring a claim for unfair dismissal if they're dismissed. Obviously, fact specific. They would be entitled to parental leave from day one rather than having to need 26 weeks continuous service, and also day one rights to sick pay. So what they're suggesting is out with needing to have worked somewhere for a particular period of time before you're entitled to sick pay. And it's what does all of that look like on employers? And I think that's the big concern, that employers are worried that given too many rights, as some might view it, from day one, is going to put a business in a position where they're afraid to recruit, they're afraid to make decisions, because they're ultimately on the hook for potentially going to court and being sued.
And I completely agree. This is the one thing out of the whole manifesto that I've talked to numerous peers and yourself about this is the one thing that is worrying me, because it does affect so much within the SME world. Now, when I was in corporate, if you had somebody that wasn't working out, probation periods, the lengthy processes, the invoice, the rights of appeal, the rights of rep, all the usual stuff that would apply before you terminate someone, normally still applies in the big companies, because they have these bigger policies with a lot. They tend to go with the processes that are when someone is 2 years or over. But within the SME market, they don't always have the opportunity to do that. So the short-term dismissal, where it is common within the SME and the smaller companies, if it's just not working out, good practices have at least had a couple of conversations with them. But sometimes the reality is that's not practical. And we see many employee, unfortunately, dismissed in the first 2 years under short-term termination. But this basic day one right is going to kind of diminish that, albeit you will have to have very watertight probation processes that will enable, and we don't know what that looks like. We're hoping that we can still follow that process within probation, but with the current legislation, you can still do the short-term dismissal outside of probation, whereas I think that will completely diminish and it'll be within probation possibly. There'll be a much shorter process, but it'll still be heavily monitored. But I think so enabling you to make sure you recruit the right people, you follow probation, but then removing that right to remove somebody a lot quicker when it suits the needs of the business and it's the right thing to do is really going to affect small businesses. And it is going to make them afraid to recruit people. I think the other thing we talked about in relation to this as well was as a business, we have seen a massive increase this year with ACAS conciliations, ET1s arriving in for clients. And we've seen a big change in, I think the ET service is not coping with the volume. And we're seeing that with how late we're getting ET1s and ACAS conciliations, hitting inboxes of our clients. And then you've got very little time to manage that process. We're also finding with ACAS conciliators now that they're a lot harder to get hold of. You can't just pick up the phone to them now. They'll book you in with a date and time and you have to go into their diary, but you can't just pick up the phone to discuss a case with them. And we also talked about one recently as well, where we've noticed on the ACAS website now that there's a change in relation to where people wish to lodge their intention to bring a claim under ACAS conciliation. There's a little tick box now that's appeared that enables people to completely skip the ACAS conciliation and get issued with a certificate straight away. And the challenge that's going to bring for the small businesses is an ET1 lands in their inbox. They've never had ACAS conciliation. And actually, when you look at sometimes these claims that are arising, they actually don't have the service to bring some of these claims. So they're bringing unfair dismissal with less than 2 years and there's nothing else on there. But it's creating a cost for the business because they're having to pull everything together. They're having is right, but it's creating a cost for businesses to defend that ET3 and meet that very strict deadline on a case that you know is going to end up in front of a judge and they're going to kick out anyway because they haven't got the service for it. So you're not even getting a conversation to the business, and it's worrying me that I think in a genuine case for someone that's got a claim, I think it's great for employees. But for businesses, I think it's going to bring out those serial people that are going to making a claim and getting conciliations and monies from businesses who don't have the right support in place around HR employment solicitors. People are going to turn it into a career to bring claims against businesses to get money at ACAS conciliation point because it's not logged unless it goes to tribunal.
I mean, that is something that people are concerned with. Personally, I don't think that's the view that I take from reading the literature and the manifesto, because having a basic day one right is simply allowing an employee to have more stability about what are the terms, what protection do they have. And although, we do live in quite a big blame culture, win no fee kind of claims, but I don't know if that translates neatly into employment. Because most people don't want to sue their employer, and most people want to, you may have all of these rights from day one and never need to use them. And so I don't think it's something that employers need to be really concerned about. But I do think that it means that they have to be more on the ball with having robust procedures, policies in place, understanding, like you say, what is the probation period, what's the regime that still applies, that they have to, can they still dismiss somebody during probation? Are Labour going to allow that? Because I think having a blanket day one right for everything obviously doesn't translate into, there has to be provisions in place to protect business, but I think there has to be a balance in order to make sure employees have stability and have the reassurance of knowing that they have protection. And I don't think the current waiting 2 years for the majority goes as far as it should for employees. It used to be 1 year, it went to 2 year. I think we need some kind of middle ground. But I mean, even looking at day one rights for sick pay, I think that has been something that the majority of employers have disputed, that they don't want to have to pay sick pay from day one, which you can see, because that in itself will cripple small businesses who have to now find more money to pay wages when they wouldn't ordinarily need to do that from day one. So I think there's loads of things to consider, and it's definitely something that's going to be a hot topic probably for the remainder of the year now, because it affects, and like you, during our conversation yesterday, Nikki, we were talking about how many policies for employees is going to affect. There's going to be, if day one rights are introduced, it's not just one policy that an employer will need to update. It will probably be the majority of the policies that are in place for that employment that will need to be updated to ensure that the employees know what their rights are. And so I definitely think that out of all of them, that's the one that I was most interested in, because it will have such a huge impact across all sectors.
It is, and like you said, don't underestimate. I mean, that isn't just going to suddenly appear in April, because it's such a bigger piece of work that's going to affect so many other things, and so to have that time to assess and change. So I don't think it's going to be a sudden change. I think it'll be very gradual over various things that will come into play. And I think actually that will be the biggest change we'll see in very many areas over the years. I think the only thing I would hope is that ACAS and the Employment Tribunal Service review the impact it's going to have on them, because I think it will have an impact on them with the way we've seen a big rise in claims and disputes this year. But I certainly think that that's the one for me that I think is going to have the biggest impact on small businesses.
Yeah. Then I think, I mean, we could talk about one-sided flexibility all day because there's so many different topics, but I am conscious that we don't have a great deal of time left. So we should probably, the right to switch off, I think that's quite a hot topic as well, isn't it?
It is, and interestingly, I was looking at some stats on right to switch off, and there was a survey done with the Institute of Directors that was around the right to disconnect. Should the future UK government introduce a right to disconnect and switch off? And 58.22% actually said no, and only 36% said yes. So it's interesting that, that when they're doing these surveys, and then there was 4.95% that said they didn't really know. So interesting stats. But we know through hybrid working, people working from home, the way technology in the world has changed, work has sometimes become 24/7, and there is a lot more boundaries being crossed in relation to text messages, emails, and what people are doing. And I think that's because people now work more flexibly. I mean, for anyone who knows me, I am that up at 1, 2 in the morning. I'm a night owl. I have a tendency to do emails very late. I certainly don't expect it of my team, and I think that's about having the right culture. But I am a workaholic because I'm a business owner and I'm always doing late. And some of my clients will get emails from me at strange times, but I do have a disclaimer at the bottom of mine that makes it very clear, that says I work flexibly and I don't expect you to respond to me outside of your normal working hours.
But I think that needs to translate. I think that needs to translate between employer and employee now. So whereas we might do that when we're writing to clients and customers, I think what Labour are really suggesting with, there's a whole bunch of family-friendly rights that you can see on that list there. They're suggesting reform and everything, flexible work and parental leave. They want to give women who return from maternity leave greater protection. So they have 6 months when they return after pregnancy where they can't be dismissed unless there's a really good reason for dismissal. You know, that they're looking at everything. And I think the right to switch off is because everything that they're looking at is to create a work-life balance.
Yeah.
And what they found is that majority of people, like you say, especially since COVID and working from home and flexibility kind of being more prominent, people don't have clear boundaries anymore. And I think the 58% of employers who said that they don't want their employees to disconnect, they, I mean, they did have valid reasons. Some of them had valid reasons. So, well, they want to be able to contact employees in an emergency, or senior management, senior staff should be able to be contacted outside of normal business hours. And I think it's about having the right conversation. I don't think a blanket, you can never contact me outside of work is going to work again, is going to be helpful for either the employee or the employer. But like when you put your disclaimer on for your clients to say, I'm contacting you, but you don't have to contact me. I think the same thing has to, you know, we probably have to have quite clear expectations. Everybody needs to know what the expectation is. So if you're an employer and you're contacting your employee out of office, out of hours, when they're on holiday, when they're not meant to be in the office, what is the expectation on them? Do they have to reply? Do they have to reply within a certain period of time? Is it up to them? Is there going to be any kind of discriminatory, detrimental treatment because they didn't answer a text message?
Yeah.
There has to be clear parameters in place so that we can't just have this blanket employees can contact us whenever we want, but there has to be the ability to contact when it's reasonable. And I think that's the thing. There's no definition currently as to what's reasonable contact. And I think it's going to be different for different sectors, different industries, because not everybody works 9 to 5.
No.
You know, so I think it is a real conversation. I've seen lots of things in the news recently about people talking about this kind of disconnection, and not a lot of employers really wanting to say that they'll never contact an employee because, of course, it's just not realistic.
And they have been introducing it in Ireland and Belgium, and I know it was recently introduced into legislation in Australia. And you know, we are very aware that where the world has changed and those lines are blurred, and you know the boundaries have been crossed and do cross, it is leading to burnout. It is leading to people never switching off, you know, and it's having a big impact in the workplace when it comes to well-being. And I think you're exactly right. It comes down to setting very clarifying, very clear expectations. So if you're in a WhatsApp chat and you're not in work, mute it, put your out of offices on, put on your emails that you're part-time and what hours you work. So there is all these different things you can do to manage it, you know, muting conversations, taking apps off your phone during holidays and things like that. It's about making sure that employers still respect that people have a home life balance, and it can lead to burnout, because there will be people that naturally want to have the finger on the pulse all the time. And actually, even though they may be happy to be contacted 24/7, you've actually, as a good employer, actually got to encourage that disconnect as well, because it does lead to burnout with people. And they can't be everything to everyone. So I think it works both ways, understanding what the employee needs, but also setting expectations on what you expect from a reasonable employer if you do need to contact for any other reason, but also making sure the welfare is at the forefront of your mind for people as well.
I mean, because we do have, you know, there's legislation in place here in the UK, the Health and Safety at Work, that says that your employer has a duty to, you know, ensure your welfare. So, you know, burnout and stress at work and everything else, that's going against what your obligation as an employer is to protect welfare. And obviously there's the Equality Act, which places further obligations on employers to make sure that you are taking care of your staff. And so the right to switch off, you should be able to disconnect. And I do think that it's more about the conversation, proper training, and also looking to see, does something actually need to be put into the employment contract about contact and when you can be contacted, and even the means to contact, because you know, is it phone, is it email, is it, what are we doing in terms of contact? Is, you know, is it really reasonable for an employer to turn up at your door because you didn't answer your phone and they need to speak to you? You know, there has to be a real conversation, and I think there has been a lot of stuff in the media about disconnection, and there are a lot of pros and cons, but I do think, I mean, they've done it now in Portugal, like you've mentioned, some other countries. In Portugal with the Labour Code in 2021, they've introduced that now, so you're not allowed to contact employees outside of hours. I don't know how that's actually working, and if there's any kind of, it would be useful to see what the feedback was from countries that have already kind of put this in place, to see what have they learned and what can we learn from that before these are really introduced later in the year or in years to come when Labour decide whatever's going to happen. So I definitely think, again, it's something that a lot of people are interested in because it is personal to all of us. We all want a work-life balance. So definitely, I'm sure we'll be having many more conversations about that one in the future, Nikki.
Sorry, I froze there, so I missed that last sentence. But so, yeah, I think that one of the biggest things is just setting on that one. So, okay, so I'm conscious of time and we've still got a few things to move forward, so I'm going to move us forward. So I've moved on to fair pay now, and I know we've got this kind of covers a lot of things: genuine living wage, the sick pay, which we've touched on slightly, you know, the fair tips, which has kind of already come into play in a way, unpaid internships, couldn't say it properly there, fixing adult social care, and reinstating school support staff for negotiating body. So we're kind of going to focus on two key areas in relation to this one. Now, we're not going to go into detail on this, but what's interesting was when I went through all of this legislation, and I'm not going to go into detail on it on here because it actually doesn't refer to every sector, but the one around fixing adult social care is actually going to affect one of my bigger client bases quite a lot when it comes to travel time between different clients and things like that. So that's certainly one that I'm going to be picking up separately with a lot of my clients and really trying to get my head around that, because I think a lot of changes on this is going to fundamentally really affect quite a large of my client base around the in-home care sector, around travel time. So that's certainly one I'm staying very close to at the moment to see where that one goes. But the two that we're kind of going to cover on here is the genuine living wage. Now, I've done a little bit of research into this, and I've looked, we kind of know that, you know, for 21 and over, it's £11.44 an hour, 18 to 20, it's £8.60. And I mean, they're talking about what the Labour government are saying is Labour government will go further and make sure the minimum wage is a real living wage that people can live on. And they're going to change the Low Pay Commission remit and for the first time reflect the need for pay to take into account the cost of living. They're also going to talk about removing discriminatory age bands, so diminishing that 18 to 20-year-old current band and bringing everyone into a single 18 plus pay band. Now, I looked at that from a cost point of view. I looked at an article that said we're going to be going to £13, and then I looked at another one that kind of said, actually, we're looking at the pay rate in April next year going to between £11.82 to £12.39. So I did a quick calculation as to what does that actually mean. So if you imagine someone who is between the age of 18 to 20 and they're currently on £8.60, if they go to that £11.82 and they bring them into, and they're a full-time worker, it's actually going to give them over £6,000 a year pay rise. Now that for one person in the SME market is huge. Yeah. And it worries me from a number of things of, is it going to lead to age discrimination? Because if people are feeling, well, I'm going to have to pay the same rate for someone with a bit more experience and who's a little bit older, are they going to start in their head, because we know it happens, kind of ignoring those CVs of the 18 to 20-year-olds, and that they want, because they're going to have to pay that rate anyway, they'll get someone with a little bit more worldly wise, as they might deem it, experience. So there's certainly, I think it's fantastic. I think, you know, the current rate of pay is still the way the world has changed. People are struggling, absolutely get it. But I think you have to balance that as to how small businesses are going to cope with all of the changes around the pay rates as well, because there was a big
Yeah.
change this year, and they're now looking at it ongoing, and they reckon it'll be part next year and then possibly a bit the following year as well.
Mhm.
But this is really going to put a lot of pressure on that SME market.
Yeah, and it's the same with the sick pay as well. So what the Labour government are saying is that not only do they want sick pay to be day one right for all employees, excuse me, they want to lower the earning limit and remove the waiting period, so you don't have to be off for a particular period of time before you're allowed to claim sick pay. And what the real problem there, or the real concern is, especially the SME market, paying those extra wages, having the responsibility and the legal obligation to do that could be quite crippling to a smaller business, especially because sickness since COVID is on the rise. Absence in general is very high. That's, you know, there's a lot out there, a lot being published to show that since COVID, we have got a really high absence rate. There's concern that if you can be paid sick pay from day one and you don't have to have been off for a couple of days before you get paid, then is the system going to be abused? Or are you going to have increased sickness and absence, which means really employers need to have robust sickness policies in place, grievance and disciplinary procedures in place to make sure that they are managing sickness, because it's probably an area that we all could do better on in terms of managing sickness. And I think we're all sometimes afraid to go into that conversation with an employee about why they're off, and you don't want to cross any lines in case you're accused of discriminating or not putting in correct adjustments or whatever it may be. And so I think the real conversation about fair pay is making sure not only is it fair to the employees, but also that the business market can actually sustain the increases that are going to come, and where we need added support from government, that it's there, that there will be something introduced to help businesses accommodate the increase in the general living wage and also the increase in need to pay sick pay. So I think this will have a dramatic impact on businesses, but things take such a long time to be brought into, you know, we don't know what they will actually look like when they eventually are introduced, if they're introduced at all. So it's not to mean that there's anything to be done now, but certainly to be aware of that, because a £6,000 pay increase to anybody who's below 21, well, 18 to 21 in your workforce is quite considerable if you've got a few employees in that age bracket.
Exactly. And you know, like you said, it is twofold. It's not just going to be the challenge around the pay for the SME market. It's actually also going to be how do they now manage absence? Because I'll be honest, through my experience in looking after SMEs, you know, I updated all of our absence policies for our clients earlier in the year, and we've really made a distinct difference around how you manage short-term IMSA and long-term absence, because those short-term, those first 3 days, employees do avoid taking them off when they know they're not going to get paid. But now if they think they're going to get paid, even if it's just a small amount, and especially if they remove that days, that they might have been put off from taking before because they couldn't afford to lose the pay. And you've got that balance of making sure people are looked after. You don't expect someone with something contagious to come into work, but and there is going to have to be really robust.
Lost you there, Nikki. Sorry, can you repeat that last bit again? You froze.
Could that mean, oh, you guys
You're just getting in and out.
introduced in some businesses? So yeah, so be a challenge. Have I frozen?
Yeah, we've got you back now. No, that's fine. We'll move on to the next bit.
I think the next slide really, it won't take us long at all, because we were just really going to focus on 2 main points of that. It was about equality at work, Nikki.
There we go.
Do you want to put on the equality at work slide?
Yeah, there we go. So off in detail is the voice at work. So, you know, we're actually not going to go into detail on this one, because when we've had a look at this is very much around what we talked about at the beginning, which it's very much the union side, getting the voice of the employees back in the workplace and unions. And I do think we'll see an increase in union presence in workplace disputes again, and people getting access during inductions and things like that. So we're not going to go through that in detail. I think, you know, that's coming. We're not going to have a lot of control, but at the end of the day, businesses and employment law doesn't change, and we still follow it. So we're going to kind of go past that one and move to equality at work.
Yeah. So yeah, the first thing really to mention is that it's been 14 years now since the Equality Act was introduced, and actually there's still huge gaps in equality within the workplace, particularly with women in the workplace. And so Labour have done a lot of research, have published a lot of literature now to show why it is that they want to emphasise equality in the workplace and what they're going to do to try to bring more reform. Whether or not it all comes in again is something we're waiting to be seen. But they are covering a lot: equal pay, the gender pay gap, which is huge. You know, looking at here, the public sector equality duty. There's loads of things that they're covering on equality, but because me and Nikki both have a passion in menopause in the workplace and neurodiversity, diversity, we thought that maybe we would just touch upon that, just to give you a flavour of what the Labour government are suggesting may be brought in, or why the thing change should occur. So did you want to cover neurodivergency first,
Yeah,
Nikki?
so obviously neurodiversity is not in the Labour manifesto, but I'll put it on there because I think it should be. So for anyone who knows me, I'm extremely passionate about neurodiversity. I discovered around about 18 months ago, through working with one of my clients, ADHD runs in my family, and I am likely ADHD, and I've kind of been going through that journey with my family and my son. I'm an ADHD coach, and I work very closely with the ADHD Foundation and multiple sectors within the North East that focus on neurodiversity. So it's very passionate but we've seen a big increase in neurodiversity disputes this year. And a lot of it is because the journeys to being diagnosed, or, you know, the NHS is 7 to 9 years to get diagnosis. So people are self-diagnosis, they're protected. There's a real lack of knowledge out there. I spoke earlier in the year at a conference in London for Daniel Barnett, where I talked about neurodiversity is not on the horizon, it is already here. And workplaces have a fundamental duty to understand what that means for the individuals in the workplace, because these people bring huge assets to a business when you understand it, and you understand the strengths that come from these individuals and how much success they can bring to a business. But there's still a real fear around it out there, and actually it doesn't need to be. But we're getting a lot of issues at the moment where even individuals are getting diagnosed, and then they think that's the end of their journey. Actually, it's the beginning of their journey, because they need to understand their own strengths, their own challenges, how that can benefit the workplace. They don't always understand where a reasonable adjustment and responsibility sits with them and their employer. And this is why we're seeing a lot of disputes, because they're quite often seeing it as once they recognise they may be neurodiverse, or they have had confirmation of something, they're thinking that's the end of the journey. Actually, it's not, it's the beginning, because there's so much the workplace can do to support individuals through access to work and organisations and coaching and support workers and devices and apps. And there's just so much we can be doing to support these individuals. So whereas menopause has become very visible within employment law, I think neurodiversity will in the coming years. And I think it's really important from a HR professional point of view that you know, we start getting ahead of the game on this and being ahead of the pack. Whereas menopause crept up on us, I think for neurodiversity we need to be ahead of the pack, because there's so much we can do to support employees in the workplace on this. And as you can probably tell, I'm extremely passionate about it.
I think you're quite right, Nikki. There's loads of things still, even like I say, 14 years on from the Equality Act, where we're only just really starting to see change. I mean, neurodiversity and menopause have affected people forever. but yet, you know, we're only now 2024 really talking about things that affect people, affect a lot of people in society. So
Yeah.
in respect of the equality at work for menopause, what the government are saying is they're touching upon further upon the things that have already been introduced, such as suggesting menopause policies in the workplace, things like that, to make sure that employers are aware of symptoms. A lot of employers have been sending staff on training for menopause, which is all great, but what it can't be is it can't be a tick box exercise. It has to be meaningful, it has to be with purpose, and it has to have a real impact upon your staff. Otherwise, there's really little point in doing it. So what the Labour government have suggested is that, yes, we already have legislation which is there to protect you, protect employees' welfare, such as the Health and Safety at Work. The Equality Act is there to make sure you're not discriminated against. Now, menopause isn't a protected characteristic, so it's not mentioned in the Equality Act as a standalone issue, but you can be found responsible for discriminating against somebody who has menopause if you treat them unfairly, and you know it does amount to having a disability because their symptoms are, as you know, meet the criteria. Or you know, it could be sex discrimination, it could be age discrimination. There's a lot of reasons why an employee could still sue an employer in respect of menopause at work. And so what the government has suggested is that any employer who has 250 members of staff or more should have a menopause action plan. And what they're suggesting is that is a compulsory plan that employees should have in place. For those that have less than 250 employees, employees, what they're suggesting is they will publish guidance and help and assistance for employees to make sure they get it right. And I think, again, there's a lot of things out there that it's a really hot topic, which is great because it's putting the focus on trying to narrow that gap, which is quite still prominent between male and female in the workplace. And so, again, it is another one to keep an eye on, but I do agree. I think neurodiversity is likely to take the spotlight, and rightly so as well, to make sure that those changes come about in the future.
Absolutely. And I mean, you know, there is a lot of, I'm hoping that, I mean, with menopause, we know there's still risk around that, even though it's not a protected character.
You're frozen again there, Nikki.
Oh, I've frozen again. Can you see me now? Can you hear me, see me?
Yeah,
I
can hear
you. And then we lost the rest.
Okay, so yeah, so menopause is obviously not a protected characteristic, but the reality is that you will need to consider menopause reasons when you look at absence levels and things like that. I mean, as someone that's on HRT and has suffered terribly with menopause symptoms, even my team can tell when my HRT is not working properly. I'm suddenly drained and want to sleep under my focus. I'm all over the place. I get brain fog. And for anyone who knows me, I can think on my feet like that. But when the brain
We got a visual of brain fog there. You went to say the word brain fog and then we lost you.
So yeah, so with brain fog, my HRT helps, but not everyone can have HRT. So I think it's really important that menopause is considered in the workplace, but I do, and there isn't a big amount of knowledge out there. We are known. I don't like to use the word we specialise in it. I would like to, I think I used a word with someone I spoke to recently where we know a little bit more than most people when it comes to neurodiversity. And I guess we work with it a lot and specialise in supporting businesses on reasonable adjustments and that. So it is a passion of mine because it does run in the family. So it's not on the horizon, it's here, and people need to start getting their heads. Now, just going back to equal pay, just something I was looking at, there was a recent case that's going to cost potentially Next in the region of £30 million. So there was a recent case that has took 6 years to come to court, Thandi and others versus Next, 3,500 current and former employees and their retail workers significantly less than equal pay. So I am hearing that Next are going to appeal against it because there's a potential £30 million cost implication, but again, goes to show 14 years to get equal pay.
Oh, we've lost you again.
Yeah, I'm not sure if the Nikki's Wi-Fi
My
now
Wi-Fi
knows that the webinar is coming towards the end and it's
okay. So yeah, so it's really interesting, equal pay. Let's hope that some of these changes don't take 14 years.
And we've just got one final thing which should only take just a few minutes, which is the very last slide, the rights to work.
Yeah.
Where again they're suggesting reform for employment tribunals, grievances, safer workplaces, and enforcement. But I think the thing that we took away from that, from looking at everything, is that a big thing for everyone is that they're suggesting, rather than having three months to bring a claim against an employer, they're suggesting that that is extended now to 6 months from the date of dismissal or the date of the act that takes place. How that will impact businesses could be quite significant. That means an employer could be waiting for 6 months after dismissing somebody, just waiting to see if they're going to be sued. It's an uncomfortable position to be in, but equally on the flip side, like we were discussing yesterday, Nikki, I think it gives employees a greater amount of time to gather funds and to gather evidence and to exhaust all of the internal procedures with their employer. So if they do need to sue an employer, they are doing it after really considering everything, rather than being under really tight time scales and doing it under pressure, and maybe making a decision in haste, like you mentioned, going to ACAS so quickly. Perhaps an employee would take more time to consider if they actually do want to go to a tribunal, if they had more time to think.
Yeah.
So I think that's something that employers need to be aware that could really, I think that's likely to come in. I think there's a real drive to create longer time periods to give people more time.
Yeah, and I think that thinking space is going to work in favour of employees. I think from an employer point of view, though, it's also going to give them longer to worry as to whether claims going to be brought against them. Mm-hmm. So I think there might need to be a balance, and I'm hoping to find a middle ground that works for both parties. And that thinking space does help, but I think it is going to give employers a lot more worry in relation to how long these things take and how long they're at risk of a claim for.
Mm-hmm.
So I know we weren't going to cover anything else off there in detail. So the next we bring to the Q&As. So has there been any Q&As come in, Zoe?
There's nothing in the group chat at the moment. If there's anyone that wants to put anything in the chat, please do. Or if you want to use your little hand up tool, or just unmute yourself and sorry.
I think the thing to take away from it, because there's so much to cover, that this is just kind of, it's a really overview as to what me and Nikki think what Labour might mean, because they haven't really explained themselves fully, and they haven't given a lot of real assurance as to when changes might come into place and what changes will actually be adopted and not. So it's just more, I think it's important to have a conversation now, but I'd imagine we're going to have many more conversations as things progress.
Yeah, we will, and we know there's obviously going to be bigger announcements from Labour, what's coming at the end of the 100 days, at the end of October. We obviously will organise another webinar in early November once we've had time to digest what the next phase of what there is that they're saying. And, this is not all going to suddenly happen next year. There's going to be a time frame on this. And we can only talk about our opinions on how it's going to affect businesses. It's not what it truly looks like yet. We can only talk about what we think it's going to look like. So yeah, has any questions come in, Zoe, whilst we've been yappering there?
Not on the chat, but as I was just about to say, if you want to use your reactions, anyone, so if you go into them more, and you can go to reactions, and you can do a little hands up or a thumbs up if anyone wants to do that, or just unmute and shout out. Feel free. We'll give you the floor for a minute if anyone would like to add any comments or concerns. There we are, Maggie. Yeah, you just unmute yourself, my dear, and you can crack on. probably be in your bottom left-hand corner.
Yeah,
There
first
we
of all,
are.
first of all, thanks very much for the update today. I found it really useful, but a little bit depressing. We've just literally taken the words out of my mouth. We were promised so much, I'm afraid, by the government. The protective characteristics really do bother me. And the protection for the 0 hours, because I work with quite a few people who work as in ESOL, English as a secondary language. And of course, all these very highly trained tutors are on 0 hour contracts. And it's an absolute nightmare for them. I can, I hear the frustration, and they really get a bad deal, although I do accept in some, like you were saying, Nikki, that some people I quite like them. They like the flexibility of them and to work around. But as you say, it's more, I feel a bit on the unknown again. And any idea when the government are going to address this, or are they going to give us another 100 days, do you think, or what?
I think, sorry, Hilary, I'll let you go ahead.
So I think it comes back to, so the 100 days is due to end at the end of October. So we'll get more information at the end of October. I think that the key thing I would say to anyone is don't panic, because we actually don't know. And this is just us talking through some of our thought process. And we're certainly not here to make anyone panic, because if you're on here, then you've got a genuine interest and curiosity to get things right. Otherwise, you wouldn't be on here. And there will be guidance and people out there to help you get it right. That's what we all do. A lot of it in my sector and what we do. I think the update end of October, we'll obviously do, myself and Kat will get our head buried and do another update in November about what does that now potentially look like. But I think me and Kat talked about this yesterday. I think there's an assumption that all of a sudden all this is going to happen in April. It absolutely.
Yeah, I don't think we're going to see big changes immediately. I think it will take some time before anything really is implemented.
Yeah, it's
sorry, Nikki, you cut out.
I cut out again. So Wi-Fi. So it's an unknown. It's not going to all happen for years. And we'll just, they won't throw it all us at once, because I know businesses won't cope. So what will come will come. We will be given time on some of it, and some may be a bit quicker. But we'll know more at the end of October.
Yeah,
thank you.
Hopefully we can do another update in the future when we're talking about what we know is actually coming in. But I suppose all we can take away from today really is that we know absolutely there will be changes. What they look like, we don't know for certain. But this year, what employers do need to focus on is the allocation of tips if it's relevant. If you need to get on top of that, and also the sexual harassment in the workplace. Those are two of the changes that are absolutely coming into place. And therefore, if you take anything away from today, it's making sure that you have those aspects of the business nailed down, because that's where you may get into trouble if you haven't got policies and procedures in place for when they are introduced later in the year. Which, sexual harassment in the workplace is, I keep thinking October's miles away, but it's actually next month. So, we're not too far away from the implementation of that act. So now's the right time to get things ready for that, to make sure you're ahead of the curve.
Any more questions from anyone?
Any more questions come in, Zoe?
Oh. No, I'm just asking now. I'm guessing you missed that because of your Wi-Fi. Does anyone else want to either raise their hand or unmute and ask any questions? Or feel free to put anything in the chat. No? Wonderful. So just before we'll wrap up for the last couple of minutes, we've got a couple of last things to share. First thing is I would like to ask you all to do is I've just shared our LinkedIn page. So everything we do with events and anything we do in terms of supporting you guys with any free advice like this is all going to be on that page. So drop it a little follow. Excuse me. With next steps, so you'll get an email, as Nikki mentioned at the start. You're going to get an email with the recording. You're going to get an email with the slides, and you're going to get an email with a link to that document. That's going to come from me, Zoe Malem at Inspired HR. So make sure I'm marked as a safe sender, and we'll get all that over to you. On that, there'll be an option for you to follow up with more information with any of the team if you want to have a discovery call or anything like that. But I'll also attach the business information so you've got it. Me and Nikki and the rest of the team at Inspired HR, we're really passionate about helping businesses be better for and with their people. Now, obviously, there's cost that comes with some things because we all have bills to pay, but we do quite a lot for free. We do a lot of networking events. We do a lot of one-on-one. So if there's anything we can help with, please just ask. Totally open to what we can support there. And then on the next slide that Nikki's about to show you before I lose any more of you. Nikki,
just bear with me 1 second. So I'll just quickly touch, because I know Kat's got some next steps. So just a few next steps from me and Kat. Make sure you update all your contracts, your policies, and you implement exactly what Kat said around the tips and the sexual harassment changes that are here and coming in. Ensure correct holiday calculations and 0-hour contracts are being used correctly now. We're still seeing a bit of an issue with the wrong holiday calculations still being used. Do obviously read up on Make Work Pay so you're familiar with what's coming. And then obviously for our clients, don't worry, you'll get everything from us. If you're a retained client, you'll get your updated policies, we'll be in contact. We are currently designing a suite for the sexual harassment and the bullying harassment and various documents and training. And we are also going to be rolling out some master classes that will be like short 45-minute training sessions on all different subjects. So keep an eye out for those because they'll come up. We do have another event coming up next week, which is, I'll hand back to Zoe because she can talk a bit better than I can.
Yeah, so if anyone's got their phone in their hand, there's a QR code here, but that'll also be emailed out to you. And as mentioned, we're really passionate about helping people do things a little bit differently. And with that is that we're going to be talking about inclusive culture and how you can actually craft an inclusive culture in your business. I'm aware that we've got some people outside of the region on the call, so unfortunately, I totally understand that a train ride for a lunch wouldn't be appropriate. But for anyone who is in the Northeast who would like to come for lunch, there's a lot of networking. It's all for business leaders, and it's very much around having that conversation and that peer support, Chatham House rules type thing. But that's pretty much everything from me. We will, on the screen now, you've got some further, again, these will be sent out to you, but like I say, if you've got any questions that pop into your head in the next 48 hours, please don't hesitate to contact us, connect with us all on LinkedIn. And if you think of anything else, please let us know. Thank you all so much for your time. And again, thank you so much, Nikki and Kat, for your
thank you, everybody.
We'll see you every week.